Chapter 2. The custody. On the first attack of lunacy or other occasional insanity, while there may be hope of a speedy restitution of reason, it is usual to confine the unhappy object in private custody, under the direction of the nearest friends and relatives, and the legislature, to prevent all abuses incident to such private custody, has thought proper to interpose its authority by Stat. 14g. 3. c. 49. Continued by 19g. 3. c. 15. And made perpetual by 26g. 3. c. 91. For the regulation of private madhouses, see postua. But when the disorder is grown permanent, and the circumstances of the party will bear such additional expense, it is proper to apply to legal authority to warrant a lasting confinement. The king's prerogative, in this case, is well founded, and well recognized, upon the principles of equity and justice, and therefore the legislature hath invested him with the custody of the lands of idiots, during their lives, and of lunatics, during their lunacy, for their own use. At the making of the Statute of Magna Charta, 9 Hen. 3. The king was not possessed of this prerogative, for if he had, this statute would have provided against waste, and c. committed by the committee. The guardianship was vested in the lords, or others. According to the common law, idiots from nativity were then accounted only as infants within age, therefore the custody of them was perpetual so long as they lived, for their impotency was perpetual, and the lord of whom their land was held, failing of a tenant to do him service, therefore took the wardship of him, as he did the custody of a minor. It is certain that the king exercised this prerogative before Stat. of 17 Edward II. De Piacia Regis, for it appears to have been exercised by Ed. I. And it is as clear that when Bracton wrote about the end of the reign of Hen. 3. that the king had not possessed it. Hence it follows, that it must have been given to Edward I. by some statute not now extant. And it appears by the Mirror agreeing with Flitter, that this prerogative was granted by common consent, and this is acknowledged by Stamford. It was anciently held that the king took to his own use, and therefore might demise at rent, all the possessions of a natural fool, not of any other idiot, during his idiocy, but not that which he had title to by entry or action, and therefore upon office, finding that the idiot's ancestors died seized of an estate tail, it was sufficient to traverse the dying seized, for that only entitled the king. As it was presumed that natural fools could never attain any reason, their guardians, on this pretence, anciently took care of their lands in fee, but, as many others also suffered by this kind of disorison, it was provided 17 Edward II. c. 10. And generally conceded, that the king should have the custody of the bodies and inheritances of idiots and fools in fee, whilst they were so from their birth, yet otherwise if they lately became so, under whatsoever lord they held, and should give them in marriage, and save them from all disorison, yet, with this addition, that he should not deprive the lord of his services, reliefs, and the like, until the idiots were of lawful age. It seems to have been the general practice for the lord to commit the custody of the idiot's land to another, for he is not liable to a forfeiture, but this was disallowed after the above statute, unless some special custom could be shown which authorized it, and it was held in this case, that the committee could not bring an action in his name, being only as a servant appointed by the lord to keep possession for one who could not keep it for himself, and this doctrine seems to have been founded on Beverley's case, 4 Rep. 126, where it was agreed, that the idiot might have a quare impedit in his own name, which was afterwards recognized. The principle of vesting in the crown the person and property of idiots, is also well founded in the general principle of the monarchical part of the British Constitution, for as the social compact is mutual by allegiance on the one hand, and protection on the other, so those who are incapable of allegiance, seem to claim that protection which, though they cannot purchase by their persons, is yet contributed for by their possessions, and called for by their imbecility, and Fitzherbert says, the king, by the law of right, is to defend his subjects, their goods and chattels, lands and tenements, and therefore, in the law, every loyal subject is taken into the king's protection. Hence the king ought to have him, who cannot defend or govern himself, nor order his property, in his custody, and to rule him and his property. Thus the king, by his prerogative, has the sole interest in him, of granting the estate of an idiot, to whom he pleases without any account, but it is otherwise in cases of lunacy, for the grantee takes nothing to his own use, but must give security to account to the lunatic if ever he shall come to be capable, or else to his legal representatives. This distinction has been carefully regarded, and it has been determined with great precision, that a jury may find a person an idiot, without adding from his nativity, or for any number of years, for the law does not allow of any other idiocy, than from birth. The grant of the person of an idiot couples an interest with a trust during the idiocy, and therefore it descends to the executor of the grantee. The object of thus vesting the lands and goods of idiots and lunatics in the crown by statute, de prerogativa regis, was founded upon the most benevolent principle, to protect them from waste and destruction, that they and their household, or family, may subsist and be competently maintained out of its profits, and that any surplus might be preserved for their use upon their recovery. Hence it is that the lands cannot be aligned within that time, nor can the king seize any part of them to his own use, but is bound to repairs, and if the party happen to die during his indisposition, the residue which was formerly applied, by the advice of the ordinary, in masses for his soul, is now paid over to his administrator or executor. The Court of Wards, where these cases were once cognizable, and which was established by 32 Hen. 8. c. 46 A.D. 1540, was abolished by Stat. 12 Car. 2. c. 24 A.D. 1660. Thus it appears, that though the custody of the idiot, and of his property, vests in the king, yet the freehold remains in himself and for his use, but he is, nevertheless, wisely restrained from alienation, and if he were to convey any part of his estate, the king, by syrophases, against the alienee would reseize it, provided such alienation was made after inquisition found, from which time only the king's interest accrues. Yet it has been held, that to prevent encumbrances, this finding has relation back to the time of the idiot's birth. But, if a person had once understanding, and became a fool by chance or misfortune, the custody of him was not given to the king, and if he had so much knowledge as to measure a yard of cloth, number 20 pence, or rightly name the days of the week, he was not accounted an idiot, and the king had no prerogative. But in a case, where there was a general finding, and afterwards it was said, for so many years, and not from his birth, it was held to have been from his birth, and the latter words to be surplusage, and the king's prerogative took place. The king is thus rendered by the law the grand keeper and trustee of the persons and fortunes of idiots and lunatics, for their protection and maintenance during their lives, and at their deaths to render the estates to their heirs, so that they themselves cannot waste it, nor their right heirs be disinherited by their unfortunate situation. There is a great difference between an idiot and a lunatic, in the Stat. of Edward II, which says, that the king shall have the interest and custody of idiots. But when it speaks of lunatics, it says that the king shall provide that their lands be safely kept without waste, and they and their household be maintained, as in Beverley's case. The cases of infants, and idiots or lunatics, though often coupled, are by no means similar, upon the whole view of them, and therefore I have wholly avoided offering any parallel, and have endeavoured to avoid drawing a simile of one to the other. Besides, it is to be considered, that the crown takes the one as a trust, though coupled with an interest, and the other purely as an interest service and duty owing to him, and which comes to the king in point of tenure, and therefore the king may grant the custody of a ward cum acciderit, but there can be no such grant of the custody of an idiot, if the emolument and advantage that by law are vested in the king, in the case of idiots, could be separated from the trust, then clearly it might be transferred, and there has not been any such grant since the making the Stat. of Edward, and the inconvenience is apparent, for if a grantee makes an infant executor, or dies intestate, what shall then become of the custody of the executor? The distinction, established by statute, between the king's interest in the lands of an idiot and lunatic, is advanced in the books which speak of this matter, and, On this foundation, it has been resolved, that the king may grant the custody of an idiot, and his lands to a person, his heirs and executors, and that he had the same interest in such an one as he had in his ward, by the common law. But the king cannot grant the custody of the body and lands of a lunatic to one to take the profits to his own use. In whatever county a lunatic happens to be, the care of him devolves upon that county. Where the custody of a son, who had committed acts of extravagancy and disorder when he was drunk, was committed to a friend by the father, and after his death continued by the mother, at whose death the son was discharged by a homine replegiando, the court held that the trustee had no right to retain possession of the estates and rents to which the son was entitled, in order to convey them to persons to whom they were devised over in the event of his lunacy, and there appearing an undue contrivance to effect this, he was ordered to pay costs of suit. Barnard 358 1740. While the lunacy of any person is in question, the court will make a provisional order as to his effects, till that point is determined, and will stop the removal of the lunatic, and this is perfectly consistent with the general supervision vested in the Crown in such unhappy cases. Lord Chancellor King, upon a regular application, sent a messenger to stop a lunatic at Street Albans, who was on her road to Scotland, conducted by her husband's nearest relation, and ordered a commission to be issued, and the rents of her estates to be remitted hither. A caveat may be entered against issuing a commission of lunacy, and, on hearing the question, a personal examination in court will be ordered, and if upon the whole the lunatic gives coherent and rational answers about his estates and property, though he may be deficient in other subjects, and particularly as to the commonest question of figures, this weakness will be deemed no foundation for a commission. But this is not conclusive, further applications may be made. Perhaps he may grow worse, and at last become non compos mentis. Where the property of a lunatic is too small to bear the expenses of a commission, the court, on petition for a reference to the master, to inquire the state of her fortune, and a proper maintenance, will make such an order, upon proper affidavits, without any reference for payment of dividends for the 2 ensuing quarters. There are many similar instances on the register's book. And where imbecility of mind proceeded in a great degree from epilepsy, 7 Lord Ellenborough ordered a physician to consult with those already employed, and afterwards in the most tender manner, to find the means of visiting the patient, without alarming her, for the purpose of determining whether she was in a state of mind to manage her own affairs, and in the meantime restrained her from executing any power of attorney. If a beneficed clergyman becomes lunatic, his living is not vacated thereby, so as to let in the patron to a presentation, but it is most advisable, for his next relations to see that the duty be properly supplied, otherwise the churchwardens may, ex officio, apply for a commission of lunacy, and with the permission or approbation of the bishop of the diocese, obtain a sequestration, and employ a fit person themselves, as a curate, or the bishop, or his archdeacon, may appoint a curate. In the case of Hall v. Warren, after the finding under the commission, the living, which was in the diocese of London, was sequestrated, and the incumbent soon afterwards died. The object of the ordinary in sending out his sequestration, is, that the cure should not remain unsupplied, and to preserve its profits, which, as in cases of death, or during suits, is for the benefit of the successor, so in cases of lunacy are, upon the principles stated in another part of this work, for the incumbent upon his recovery. The persons appointed sequestrators have a duty somewhat similar to that of a committee, first giving bond for their fidelity to the ecclesiastical judge in gathering the profits, and rendering a true account. They cannot maintain any action at law for tithes in their own name, but only in the spiritual court, or before the justices of the peace, where they have power by law to take cognizance. In passing their accounts, they are allowed out of the profits a reasonable sum, according to their trouble in gathering the tithes, and for supplying the cure, and in maintaining the incumbent and his family. If upon recovery he is dissatisfied with their measures, his proper remedy is in the spiritual court, and if he files a bill in equity, the bishop must be a party. Upon an information in the King's Bench against a physician, for assaulting and beating an alderman, under pretence that he was a lunatic, for imprisoning him until he procured him to execute a letter of attorney to his wife, by colour of which he disposed of 1,000 litres. in value, apparently to his own use. It appeared also that he had debauched his wife, handcuffed the husband, given him several strong purges in the night, and carried him out at 1 or 2 o'clock in the morning bareheaded when it rained. He was sentenced to stand in the pillory, to be sent to the House of Correction in Southwark, to be whipped naked, and to be kept at work there for a year, to be fined 600 litres, and to find sureties for his good behaviour during life. Rex v. Dr. Fellows, E. 12 Ann. Fortes, 166.